In 1898, a Manhattan probate file opened for a major Gilded Age estate, and then never reached final. The docket stayed technically open while assets around it kept moving, as if the record was being given time to fall behind reality. This video examines the Gilded Age estate inventory that was never completed, a probate inventory tied to a New York surrogate's court file in 1898, where the central ledger of a wealthy estate remained open long past the moment it should have been closed. And the mini-verdict is simple. For an old money estate of that scale, an inventory that never reaches formal completion is not a neutral administrative hiccup. It is an institutional condition that creates leverage. The first concrete anchor is not rumor or family lore, but a docket entry and its early filed inventory schedule. The kind of itemized list submitted to the surrogate's court and mirrored through the county clerk record trail, where a case number, dates of filings, and procedural status become a timeline you can verify. To understand why that matters, you have to place yourself inside the reputational economy of the late 1890s. New York was the nerve center of capital, society, and scrutiny, and the line between private decisions and public image was thinner than families admitted. The press did not need a scandal to cause damage. It only needed a vacancy, an ambiguity it could name and repeat. By the end of the decade, after the panic of 1893 reshaped fortunes and forced quiet, restructuring, the ritual of probate, was supposed to do the opposite of improvisation. It was meant to freeze an estate in place long enough to measure it, declare it, and transfer it cleanly. An inventory was not just paperwork. It was a public-facing assertion of legitimacy. What existed, what was owed, what could be inherited without dispute. And yet, in this case, the record behaves in a way that shouldn't exist. A large estate inventory that lingers as unfinished, year after year, without the clean procedural closure you would expect even from a complicated family. The practical consequence is not abstract. While a file remains suspended in that half-lit administrative state, assets gain time to change form, shift titles, and blur traceability before an official conclusion pins them down. That is the tension at the heart of this story. Not a theatrical mystery, but a measurable gap between what the court record says is pending and what the real world implies kept happening. If you had to open one drawer in the county clerk's office and choose one document to read first, which would it be? And if this intrigues you, subscribe so you don't miss the next file, and leave a like if you want this record followed to the end. We start with the docket itself, a case number, an initial list of property, and a status that refuses to become final, preserved like a footprint in paper, and that is where the record begins. The first document that signals the problem appears in 1899, a year after the death of the estate's owner. Bound in the surrogate's court inventory book, the file carries the signature of the court-appointed appraisers and the executor named in the will, a familiar combination of clerical precision and social discretion. At first glance, nothing seems irregular. The headings follow the required format, the dates match the filing log, and the ledger is stamped with the county seal. But the illusion of completeness dissolves after the third page. Instead of the expected enumeration of assets typical of large New York estates, paintings, securities, household furniture, land holdings, the inventory offers a series of hollow categories: personal effects, miscellaneous securities, household goods. No annotations, no cross-references, no appraisal values, a formal list that confirms possession without ever identifying what is possessed. In 1899, such omissions were not a matter of style. The state probate code demanded specificity, particularly when estates exceeded $1 million, a threshold easily crossed by the merchant families who had built their fortunes during the post-Civil War boom. Each object had to be valued, itemized, and tied to a line in the executor's bond. To deliver a list, this abstract required either negligence or intent. The handwriting itself betrays the tension. 2 inks, one consistent and strong, the other faint, added later. The margins contain penciled notes. To be supplemented, pending confirmation. But the supplements never materialize in subsequent filings. When the county clerk's microfilmed copy is examined, Those marginalia have been cropped out entirely, leaving only the official illusion. The contradiction becomes undeniable when the same estate surfaces in an unrelated publication, the New York Social Register of 1900. There, the deceased's residence is still listed as family seat, active, and a charitable donation recorded under the family name includes an artwork, valued at $12,000. No trace of that artwork, or any comparable asset, appears in the court's inventory. The omission is not a clerical accident. It is the absence of a category that would have required acknowledgement of a transfer before probate closure. When the inventory was accepted by the court, it effectively legalized a selective blindness. Once stamped received, the document became the baseline for all future corrections, however cosmetic. The executor, a trusted business associate rather than a blood relative, proceeds with the dignity of compliance. His letters to the court, preserved in a side file, describe the inventory as provisional pending further appraisal. Yet no further appraisal is ever filed. The appraisers themselves, two names recurrent in other elite estates, later appear as officers in a private trust company incorporated in 1901, precisely the period when unrecorded securities could be moved under new custodial arrangements without triggering taxation. In that sense, the incompleteness of the 1899 inventory is not a failure but a functional design. It creates a pause, a window during which property may shift identities while the paper trail remains frozen in its first draft. The legal consequence is subtle but profound. By accepting an incomplete filing, the surrogate's court allows the estate to exist in dual states, officially static, materially fluid. Assets that should have been described as shares of the Metropolitan Transit Syndicate reappear, later under different ownership. Others vanish entirely, absorbed into trusts that bear only initials instead of full family names. The procedural irregularity never escalates because the process itself provides cover. So long as an amendment remains theoretically possible, closure can be deferred indefinitely. For historians, the first inventory is the most dangerous document precisely because it looks harmless. Its vagueness is a structure, not an error. When compared to external references, ADI, charity auction notice, a property transfer in the real estate record, or even a museum ledger acknowledging a loan, the omissions form a pattern too consistent to ignore. Each missing item corresponds to a later appearance somewhere else, under an entity that did not yet exist at the time of filing. The inventory becomes, retroactively, a map of what was intended to disappear. And this raises the central reflection. If the first document, the one meant to define the boundaries of the estate, is incomplete from birth, what exactly does the court validate when it accepts the file? The answer will shape the rest of the investigation, because every subsequent correction, amendment, or closure will trace back to this moment of sanctioned vagueness. As the clerk turns the final page of the 1899 volume, the ink fades where the signatures should darken. The embossed seal catches a slant of light, revealing faint impressions of erased notes beneath it. The paper smells faintly of carbon and dust, and the absence it records is tangible. A record that confirms nothing, yet authorizes everything. And from that thin seam of silence, the next stage of the story, the decision, begins to emerge. By 1901, the landscape of wealth and inheritance in New York had changed more than most courts could keep pace with. The Gilded Age was folding into its corporate form, and what had once been personal empires of merchants and railroad magnates were turning into abstractions, trusts, holding companies, custodial accounts. The surrogate's court still used the vocabulary of personal property, yet the fortunes it handled no longer existed in such simple terms. The context into which the unfinished 1899 inventory quietly survived was one where unfinishedness itself became a tool. The New York Tribune, in a March 1901 column on estate values under revision, noted a pattern: heirs disputing assessments, executors citing unrealized assets, and estates remaining open for purposes of reconciliation. Behind this legal phrasing was a cultural strategy. A final inventory was not merely a list, It was a declaration, and declarations carried risks. Once filed, an inventory could be cited in litigation, by creditors, by estranged heirs, by tax assessors. It could be subpoenaed, printed, or leaked. To finalize a list was to lock the family's internal arithmetic into public view. For the generation that built America's patrician image, privacy had become capital, and delay was its defensive instrument. Trust companies such as Guarantee Trust and United States Trust Company expanded precisely within this loophole. They offered not only custody, but invisibility. Assets could be transferred from a deceased individual's estate into a nominee account for management, pending appraisal, an arrangement that satisfied the letter of probate compliance while erasing its spirit. The executor of the 1898 estate, whose name reappears in corporate directories by 1901 as a trust officer, would have recognized this new economy of concealment. Where the surrogate's court demanded itemization, the trust agreement offered substitution. The same holdings, recoded as fiduciary instruments beyond the court's reach. The risk lay in the optics. Newspapers like the Evening Post began publishing comparisons between declared estate values and the visible lifestyles of heirs. Townhouses renovated, new memberships at clubs, and charitable pledges inconsistent with the official figures. The Tribune hinted that incomplete inventories facilitated underreporting. To families who had lived through the Astor inheritance litigations and the backlash against conspicuous wealth after the panic of 1893, the lesson was unmistakable. Exposure invited contagion. A misvalued painting could become a headline. A missing annex could evolve into a Senate inquiry. Inside law offices along Nassau Street, estate attorneys adopted language that mirrored accounting rather than legacy. Memoranda from firms like Coudert Brothers advised clients to reserve classification of speculative securities until market stabilization, an instruction that effectively justified omitting them. Every omission delayed closure. Every delay allowed revaluation, restructuring, or quiet disposal. The danger of a frozen inventory was finality itself. Once the court affixed its seal, the family's wealth became measurable, and what was measurable was taxable, contestable, and exposable. By mid-1901, the executor's AO correspondence reveals a cautious choreography. Letters to the court acknowledging the pending appraisal, parallel memoranda to a trust company about temporary custodianship of unliquidated assets. The two systems ran concurrently but never intersected on paper. It was a performance of transparency executed in private code. To the clerk, the estate remained pending. To the banker, the assets were already repurposed. For the families involved, this dual existence carried moral and social weight. Reputations in Newport and Manhattan relied not only on generosity but on decorum, the ability to appear untroubled by audit. To admit irregularities was to invite gossip. To finalize numbers was to risk scandal. In a city where the Tribune's society pages read like financial disclosures in disguise, discretion became the final currency. Yet the structure was fragile. Every open probate file existed under the latent threat of public inquiry. Reform movements, led by journalists like Lincoln Steffens, were beginning to treat probate secrecy as part of the same machinery that sheltered political graft. The very institutions designed to stabilize fortunes, trust companies, estate lawyers, surrogate clerks, were now implicated in a narrative of concealment. For those inside the system, the fear was not immediate prosecution, but erosion, a slow loss of legitimacy. Still, leaving a probate open was safer than the alternative. As long as the file remained pending, any discovery could be reframed as correction, not confession. Executors could claim diligence instead of deceit. The law rewarded patience over precision. A file open for 3 years suggested complexity. One closed too soon implied carelessness. And so, the 1898 estate lingered, not frozen, but suspended in a legal twilight that protected its participants from both law and rumor. The consequence was institutional as much as personal. By normalizing incompletion, the surrogate's court turned process into shield. Each deferral extended the interval during which assets could be relocated, converted, or reclassified into trusts beyond jurisdiction. The same delay that insulated wealth from tax also prevented any single narrative from taking hold. When challenged by the press, the answer was always procedural. The matter was under review. The power of that phrase outlived its century. It trained an entire class of administrators to treat openness not as a virtue but as a strategy, to equate the absence of closure with control. And within that equilibrium, the unfinished inventory of 1899 no longer looked like an error. It looked like precedent. As the last edition of the Tribune for 1901 folded onto newsstands, a small column titled "Estates Still Under Consideration" listed several names, including one tied to the old Manhattan docket. No update, no valuation, just the phrase, "awaiting completion." The ink bled slightly at the edges of the thin newsprint as if time itself refused to dry. And from that quiet repetition of delay, the next act of the investigation, the decision, begins to take form. The meeting took place in March 1902 in a wood-paneled office on Lower Broadway belonging to H.W. Ames and Cartwright, the legal firm representing the executor of the 1898 estate. Present were two partners from the firm, the executor himself, and a representative of the Guarantee Trust Company, which had recently taken fiduciary control of certain assets pending final appraisement. The minutes of that meeting, preserved in a bound notebook marked "Private, Not for Filing," record the moment when an estate formally chose delay over closure. The discussion was prompted by a notice from the Internal Revenue Collector for the 2nd District of New York, who had begun reviewing large estates for unpaid succession taxes introduced under the War Revenue Act. The estate, with an incomplete 1899 inventory still on file, now risked becoming a test case. To finalize it meant assigning values to every category the earlier filing had left vague. To leave it under review preserved discretion. The lawyers advised the latter. In the language of the minutes, they resolved to request a continuance until completion of supplemental schedules, said schedules to include valuations of securities abroad. That single clause, securities abroad, created the architecture of postponement. By invoking foreign holdings, the attorneys placed the burden of delay on geography, not intention. The petition for continuance, filed April 7, 1902, framed the matter as administrative. Certain European certificates were awaiting verification of title and translation. No such translations appear in later records. What does appear is the replacement of the original appraiser with one better acquainted with overseas assets. The Surrogate's court approved both substitutions without inquiry, accepting the fiction that more information was forthcoming. Behind the formality lay an internal conversion of purpose. The executor's role changed from distributor to custodian. The lawyers ceased to close an estate and began to manage a process. In correspondence between the firm and the trust company, preserved in carbon copies, the tone shifts. Phrases like "to conclude" disappear, replaced by "to administer" and "to oversee holdings in transition." The estate became a mechanism for buying time. The Guarantee Trust Company, for its part, acted with procedural precision. Within weeks of the court's continuance, it opened an umbrella account labeled Special Estate Administration, HWA. Into that account moved several lines of stock previously held in the decedent's personal name, reclassified as "in trust for distribution." In substance, they were no longer part of the estate. In form, they remained tied to it, insulated by the ongoing proceeding. The court's delay provided the legal shadow under which this transfer occurred. Contemporaneous press coverage reflects no awareness of the maneuver. The New York Tribune of June 1902 mentions the estate only in a routine list of pending dockets. Yet inside the courthouse, clerks noticed the growing pattern. Petitions for continuance citing foreign securities multiplied that spring, many drawn up by the same firms. What had begun as an exceptional delay was becoming practice. The decision's immediate consequence was practical but profound. By the time the estate eventually filed a supplemental inventory, 3 Years later, several properties once linked to the family name had already changed title. Some sold to shell corporations, others donated through intermediaries. Each transaction appeared by then perfectly lawful. The assets were no longer subject to probate because they no longer belonged to the estate on paper. The 1902 decision had turned time itself into a solvent. From a distance of decades, the language of the meeting minutes reads almost serene. There is no hint of conspiracy, only of control. It was agreed that finality should await the stabilization of market conditions and the verification of overseas interests. A single sentence that converted uncertainty into policy. The lawyer's handwriting remains crisp, the ink dense and unfaded, as though permanence were reserved for postponement. In the physical archive of the Surrogate's court, the 1902 petition still lies folded inside the docket jacket, its edges frayed where the clerk's stamp barely touches the margin. The phrase, "continuance granted," appears in purple ink, faint but legible. That stamp, more than any signature, marks the hinge of the case, the moment an estate ceased to seek conclusion and began to cultivate suspension. The decision made in that office did not end the controversy. It defined its boundaries. Every later motion, amendment, and audit would trace back to this administrative choice disguised as prudence. The estate had learned to breathe through the gaps of procedure, to live within. The pause. On the last page of the notebook, beneath the signatures, someone added a small notation in pencil. Next meeting, reschedule appraisement, June. No record of that meeting survives. Only the empty line remains. A quiet testament to a family and a firm that discovered how to make the indefinite their most reliable asset. And from that silence, the next chapter, the alteration itself, will emerge. By 1904, the estate that had once appeared frozen under review re-emerged in the Surrogate's Court of New York County with a new submission, a document titled Supplemental Inventory and Amended Schedule of Appraisement. It arrived bound in blue cloth, bearing the embossed seal of the court and the signature of a new appraiser, George W. Latham, certified accountant and valuation specialist. The entry was formally logged on April 18, 1904, nearly 5 years after the original filing. Its stated purpose was to update and reconcile prior entries, but its true function, visible only through comparison, was to erase. The 1899 inventory had been skeletal, vague categories, general groupings, unvalued notes. The 1904 version, at first glance, seemed more complete, neatly typed columns, updated monetary figures, and appended schedules. Yet every addition concealed a subtraction. Cross-referencing the two reveals that several classes of property had not been clarified. They had been reclassified. The 1899 miscellaneous securities line, for example, has been replaced by minor participations held through fiduciary custodians. In plain English, the stocks once directly owned were now labeled as holdings through trusts or partnerships whose beneficiaries were unnamed. Even real estate had changed nature. The decedent's residence at East 64th Street, listed in the 1899 version as primary dwelling, now appears as leased property under external management. A search through the county clerk's deed registers confirms that the title was transferred in 1903 to a newly incorporated entity, the East 64 Realty Company, whose incorporators were, coincidentally, the same lawyers who filed the estate petition 2 years earlier. Thus, the house that once defined the estate's public face had become an asset managed by others, retroactively omitted from the inheritance ledger. The supplemental inventory also revises downward the valuations of several art and jewelry items, citing depreciation owing to market conditions. Yet auction catalogs from Anderson galleries show similar pieces selling that same season for significantly higher prices. The only plausible inference is that revaluation was less about accuracy than about attenuation. The smaller the declared value, the lighter the tax and the quieter the trail. The trust company overseeing the account had every incentive to endorse such moderation. It reduced exposure for both fiduciary and heir. The substitution of the appraiser himself was central to this quiet transformation. Latham's predecessor, whose 1899 handwriting filled the original margins, disappears from the record after 1902. In the amended schedule, his name is replaced by Latham's printed certification. The transition was legal, but its consequence was historical. The earlier perspective vanished, leaving only the revised interpretation of worth. Where the old ledger expressed uncertainty, the new one delivered precision, and in doing so, defined a new version of reality. Within the surrogate's court, such supplements were routine procedural filings. Yet this one bears traces of editorial intent. Several lines of the earlier manuscript were literally cut out and pasted onto new pages, their order rearranged. Photographic copies in the microfilm archive reveal faint horizontal slices where the paper fibers differ. To an untrained eye, the pages appear intact. Under magnification, they disclose physical revision, a document that has been physically rewritten to produce a cleaner narrative. The alteration was not just textual, it reshaped the legal terrain of the estate. Once the amended schedule was accepted by the court clerk, the older 1899 version was officially marked superseded. From that moment, any subsequent query or challenge, by heirs, creditors, or tax assessors, would reference the 1904 schedule as the authoritative source. The substitution of documents became substitution of history. The executor's correspondence with the trust company in mid-1904 hints at the motives, cloaked in bureaucratic language. One letter, dated June 9th, references successful reconciliation of overseas holdings under domestic trusts. Another, 2 weeks later, notes that the court's acceptance of the supplement obviates further disclosure. In effect, what began as an administrative correction ended as a legal absolution. The court validated the rewritten record without ever revisiting the original one. The consequence was durable and deliberate. The estate's tax exposure diminished. The heirs' reputations remained untouched, and the institutions involved fortified their reputations as prudent stewards. For the state, the matter was closed. For history, it was replaced. The public record no longer described a transformation of assets, but the illusion of continuity. Looking at the two inventories side by side, the 1899 manuscript in its uneven script, and the 1904 supplement in machine-typed uniformity, the contrast feels almost cinematic. The earlier document breathes with uncertainty. The later one hums with control. Each line item redefined, each valuation lowered, each reference redirected toward a non-entity that cannot be cross-examined. What the law now recognizes as the estate is, in truth, its own reconstruction. If a record can be amended to this degree without formal contest, the question lingers. When a court accepts a supplement, does it correct the past, or authorize a new version of it? The silence of the docket provides its own answer. On the final page of the 1904 submission, beneath Latham's signature, a clerk's notation reads, "Filed, accepted, entered." The ink has faded into gray, but the pressure marks remain, deep and permanent. The law had closed the file. The estate had rewritten its memory. And from this act of erasure disguised as order, the next movement of the investigation, the identification of who benefited, quietly begins to unfold. The year 1907 placed the estate, and the world around it, under a kind of financial strain that rewarded those who could move quietly. The panic of 1907 was approaching, liquidity was evaporating, and the institutions that once underwrote New York's illusion of stability were scrambling to preserve themselves. Within that turbulence, the estate that had remained nominally open since 1898 became more than a legal remnant. It became an instrument. The delay that once appeared bureaucratic now functioned as an active strategy, and one individual stood to gain more from its suspension than any legitimate heir ever could. The trustee of record was Guarantee Trust Company, but the day-to-day management had shifted to an individual officer, Charles W. Ames, the same executor who had orchestrated the earlier continuance. His dual role, executor under probate and fiduciary officer within the trust, gave him authority over both narratives, the estate that remained unfinished, and the assets that were already in motion. Between March and October 1907, as markets wavered, Ames authorized a series of transactions transferring ownership of several high-value securities and 2 real estate parcels once held by the estate into the name of the East 64 Realty Company and a newly formed holding entity, Hudson Investment Syndicate Limited. The authorization signatures match his handwriting across documents kept in both the county clerk's deed book and Guarantee Trust's private ledgers. The pattern is unmistakable. Property still listed under estate administration was sold to independent buyers, who, upon inspection, were shell companies capitalized by the trust itself. The proceeds from those sales were recorded as reinvested for estate benefit, though no distribution to heirs followed. The estate, in effect, was selling to itself, laundering assets through legality. The major heir, the decedent's niece, Margaret H. Ellsworth, held only ceremonial control. Her signature appears on a single authorization document dated August 2, 1907, approving temporary custodial transfer. For administrative consolidation, what she did not know, or could not challenge, was that the same authorization allowed the trust to reissue ownership certificates under a corporate nominee. Once converted, the assets ceased to exist as personal inheritances. They became instruments governed by the trustee's discretion. In a technical sense, the estate had fulfilled its fiduciary duty. In reality, it had concentrated control in a single institutional hand. That concentration produced tangible rewards. Internal reports of Guarantee Trust from the following fiscal year list management revenues derived from legacy fiduciary accounts, totaling $240,000, an amount nearly identical to the annual dividend yield of the converted securities. The numbers mirror each other too precisely to be coincidence. The institution did not steal the estate, it absorbed it. Meanwhile, the heirs benefited only in appearance. Their names adorned charitable donations, endowments, and society pages announcing restorations of Newport cottages and philanthropic bequests to hospitals. Yet none of these came directly from distributed inheritance. They were funded through controlled stipends released by the trustee, who maintained the illusion of generosity while holding the capital intact. Every newspaper mention of family benevolence was, in truth, an advertisement of dependence. In October 1907, when the Knickerbocker Trust collapse triggered a run across New York, Ames personally petitioned the Surrogate's court to further delay the estate's closure until market stabilization. The language of prudence masked a defensive maneuver. So long as the estate was unsettled, its funds could not be requisitioned or audited under emergency banking inquiries. In those 3 months of chaos, while other fortunes were liquidated to cover margin calls, the assets tied to this unfinished inventory remained untouchable. The very incompletion of the process became an insurance policy against the panic. The immediate consequence was financial insulation. The longer one was institutional dominance. When the market stabilized, Guarantee Trust emerged stronger, its fiduciary divisions expanded, and Ames, who resigned quietly in 1908, retired to a new residence in Tarrytown purchased under his wife's name. The public record lists the buyer as private citizen, though the funds originated from a trust commission account associated with the estate. It is not criminal, but it is unmistakable. In retrospect, the silence of 1907 was not an accident, but a redistribution. Each document filed under continuance had given the trustee an additional interval of unchecked authority. Each amendment that diluted specificity transferred another measure of control. The estate that began as a memorial to personal wealth ended as a mechanism of institutional profit. When viewed through the surviving paperwork, the layered signatures, the reissued share certificates, the shifting ownership of the East 64th property, the question of inheritance becomes secondary. The true beneficiary is neither heir nor executor. It is the system that learned to convert delay into dominance. The unfinished file produced income without accountability, influence without ownership. In the Surrogate's Court Index for 1907, the estate still appears under the notation, pending further appraisal. The handwriting is lighter now, ink faded from exposure. Next to it, a clerk's note reads, "Trustee reporting regularly." Nothing more. The process had consumed its own purpose. And from that quiet asymmetry of gain, the reward of the one who managed time rather than wealth, the story advances toward its next layer, the things that quietly disappear. By 1911, the record begins to thin. The Surrogate's court still lists the estate as open, but the trail of physical holdings, the land, the securities, the tangible proof of wealth, starts to dissolve from public view. This is the year when the estate stops being traceable as property and starts existing only as memory. The mechanism is not destruction but transformation. Ownership quietly replaced by incorporation, names substituted by entities, ledgers edited until the subject no longer matches the object. The first clear sign comes from the New York County Registry of Deeds, March 22, 1911. A transfer is logged for the townhouse at 41 East 64th Street, once the cornerstone of the decedent's holdings. The grantee is not the family, nor the estate, nor even the East 64 Realty Company, which had appeared in earlier filings. Instead, the deed lists a new corporation, Mid-Atlantic Securities Company, formed in Delaware just months before. Its incorporators, 3 men from the same legal office that managed the estate, serve as proxies. No cross-reference ties this sale to the Surrogate's court docket. The transfer occurred without the estate ever recording a formal alienation. On paper, the house simply ceased to belong to the dead and never began to belong to anyone living. The same pattern unfolds across multiple holdings. A parcel of undeveloped land in Tarrytown, previously referenced in the 1904 supplemental inventory, vanishes from tax rolls after 1910, resurfacing as part of a subdivision managed by Hudson Investment Syndicate Ltd., the same entity used during the 1907 redistributions. Its chain of title skips a link, the deed jumping directly from a dormant estate entry to a corporate sale, leaving no trace of intermediate conveyance. The gap is perfectly legal, provided no one insists on continuity, but continuity was precisely what the estate had spent a decade avoiding. Artworks suffer the same fate, though less visibly. The 1899 inventory listed paintings and framed works, undetermined value. The 1904 amendment rephrased them as items on loan. By 1911, the family's social correspondence mentions gifts to the Metropolitan Museum of Art, yet none of those pieces appear in the museum's accession logs under family or estate attribution. Provenance research identifies several of them decades later, anonymous donations through the securities company. Anonymity had become the final custodian. Examining the Registry of Deeds microfilm from 1911 reveals telltale marks of deliberate omission. Margins trimmed, clerical cross-references left blank, sequential pages missing identifiers that every other entry of that month carries. A clerk's note at the bottom of one reel reads, "Book misnumbered, corrected in subsequent volume." The correction never came. Whether by accident or instruction, the estate's footprint was erased by the very system that preserved it. The disappearance also extended to intangible assets. Corporate charters held by the estate's earlier entities were either dissolved or absorbed in mergers during the pre-war consolidation wave. The East 64 Realty Company, incorporated in 1903, files no annual reports after 1911. The state registry lists it as inactive, charter surrendered. Its residual assets, identified in a liquidation notice, were transferred to affiliates. The affiliates are not named. A corporate death certificate without heirs. What vanishes here is not simply money, but jurisdiction. By 1911, the remaining wealth had escaped the legal perimeter of probate. It existed inside companies, trusts, and accounts immune to retrospective audit. The Surrogate's court could no longer demand reconciliation because, formally, there was nothing left to reconcile. Every tangible item that had once anchored the estate, land, art, bonds, had been transfigured into entities that required new litigation to even identify. The estate had, in essence, disappeared into its own reflection. The social world adjusted effortlessly. The Ellsworth family, still prominent in Newport and Manhattan, hosted charity galas, endowed scholarships, and appeared in the New York Herald Society pages, each event framed as continuity of legacy. Yet the legal corpus of that legacy no longer existed. The fortune that funded the reputation had no identifiable source. Its instruments were shadows of earlier holdings. For the public, the family remained synonymous with stability. For the record, they owned nothing. This disappearance had a consequence beyond wealth. It tested the purpose of record-keeping itself. A legal system built to document transfer of title had instead documented its own impotence. By accepting successive amendments, continuances, and supplemental filings, the court had become an accomplice to subtraction. Every missing deed, every vanished asset, represented an institutional decision to prefer tidiness over truth. Standing in the county recorder's archive today, the file still bears its original docket number, embossed but faded. The 1911 entries end abruptly, the last page stamped, "Received, no return." The ink has oxidized into a dull brown, and where the paper thins under the stamp, light passes through like an admission. What began as inheritance had become absence. And from that void, the estate's slow retreat from paper into myth, the next question emerges naturally. If assets can vanish without scandal, what inconsistencies were quietly left behind to explain their trace? After 1911, the estate's disappearance no longer resembled an event, but a condition. What had begun as isolated omissions evolved into a permanent absence structured by continuity itself. In the county recorder's later indexes, 1912-1915, traces of former estate properties are not listed as transfers but as discontinued parcels, a bureaucratic euphemism that effectively meant erased by redefinition. The language of the registry adapts to the silence. It no longer records what vanished, only what still circulates. Cross-referencing the old docket with insurance and mortgage ledgers from the same period reveals another layer of attrition. Properties once insured under the decedent's estate policies now appear covered by corporate instruments with neutral names: Metropolitan Title and Loan, Fidelity Realty Associates, Empire Securities Trust. The policy numbers remain identical, but the insured party changes, proof that the assets persisted, only stripped of identity. These transitions required signatures, not sales. The legal shift was administrative, not transactional. Each alteration added distance between the court's authority and the wealth it once nominally oversaw. The art and artifacts followed parallel routes of disappearance. An 1899 appraisal mentioned a portrait in the manner of Sargent, valued modestly. A 1912 exhibition catalog from the Boston Museum of Fine Arts lists a nearly identical portrait under anonymous loan from a private collection. The provenance line ends with a dash. No donor, no lender, no estate. Decades later, the museum's records would quietly attribute it to a gift of a New York family foundation. The object had crossed the line from belonging to anonymity through pure bureaucratic momentum. Even within financial archives, absences multiplied. The Guarantee Trust Company maintained its fiduciary reports to the Surrogate's court until 1913, after which the filings stop abruptly. The next annual statement notes, "No active probate accounts under administration." This was not a declaration of closure. No court decree finalized the estate. It was a linguistic substitution, a statement that nothing remained to administer because what existed was now elsewhere. A deeper look into Delaware. Incorporation records shows that between 1909 and 1912, at least 6 companies were formed by individuals tied to the estate's law firm, each dissolving within a few years after transferring their holdings. They operated like bridges, created to carry assets across jurisdictions and then disappear. Each company leaves behind the same trace: an initial filing fee, a single address, often a law office or bank branch, and a dissolution certificate signed in blank. Together they compose a geography of erasure. The legal consequence of this diffusion was irreversible. Once assets became fractional, shares, participations, anonymous securities, there was no path for the probate system to reclaim them. The surrogate's court's jurisdiction extended only over identifiable property. What could not be named could not be retrieved. By the end of 1911, the court's records of the estate occupy 3 pages: the original petition, a continuance order, and a note reading, awaiting supplementary report. The supplement never came. In the silence that followed, institutional memory did what it always does. It standardized absence. By 1915, the docket was archived under the heading Inactive Estates pre-1900, stored not among contested cases but among closed ones. There was no ruling, no closure, no acknowledgement that anything remained unresolved. The estate's incompleteness was administratively identical to completion. Looking back, this disappearance speaks less of conspiracy than of refinement. The mechanisms that enabled it, delays, supplements, continuances, reclassifications, were not flaws but features of a system built to prioritize order over truth. Every vanishing asset was an act of adaptation, the law evolving to preserve the illusion of completion. If one visits the Surrogate's court archives today, the docket folder still exists, its edges frayed, its title faintly legible in pencil. Inside lie blank interleaves once meant for attachments that never arrived. The i.e. absence has physical weight, a hollow file that survived a century by containing nothing. In that void, the investigation reaches its pivot point. What began as a record of possession now becomes a study in contradiction, the first shadow of inconsistency that the next inquiry will have to confront. The inconsistency emerges in 1913, preserved not in revelation, but in routine, a single sheet from the Surrogate's court ledger bearing a date that cannot coexist with its own content. It records an appraisal confirmation for assets that, by every traceable record, no longer existed. The figure of $327,400 attributed to estate-held securities is certified as current value as of April 10, 1913. Yet those same securities, railroad bonds issued by the Hudson Investment Syndicate Limited, had been dissolved and reissued 2 years earlier under a different corporate name. What the court affirms as value is, by then, legal vapor. The signature at the bottom complicates the paradox. It belongs to Charles W. Ames, the executor trustee whose authority ended in 1908 when he formally resigned from Guarantee Trust Company. His name, written in the same bold hand visible on earlier petitions, reappears here as certifier of an appraisal conducted 5 years after his exit. Beneath it, the countersignature of Edward Langford, deputy clerk of the Surrogate's court, attests verified in person. Yet Langford's appointment records show he assumed that post in 1914, not 1913. 2 men attached to 2 incompatible timelines authorizing a document that validates non-existent assets. The contradiction might seem clerical, if not for the precision of its outcome. The appraisal's inflated total exactly offsets the estate's reported tax liability for that year. It balances the books perfectly, too perfectly, to be accident. When the State Tax Commission audited estates in 1916, the one in question passed review without irregularities. Inconsistency had become invisibility. The margins of the page carry pencil notes by an assistant scrivener, initials RT, followed by the words substitute copy filed, original misplaced. That phrase, buried in the procedural language of bureaucracy, transforms the entire file. A substitute copy implies the existence of an earlier version, lost or destroyed, that might not have carried the same numbers or signatures. Whether the replacement was commissioned by the court or provided by counsel is never clarified. What matters is that the Surrogate accepted it, stamping filed April 16, 1913, thereby converting fiction into record. Further inconsistencies ripple outward. Property tax receipts for the 41 East 64th Street address list the owner as Mid-Atlantic Securities Camerino, yet the appraisal attributes the same property's rental income to estate-managed holdings. The company and the estate cannot both receive proceeds from the same source, and yet, in the arithmetic of the 1913 report, they do. The ghost of ownership is treated as substance, the record as reality. These incongruities were never contested because each benefited the same direction, the narrative of procedural health. They made the file look active, compliant, unremarkable. A delayed inventory is suspicious. A reconciled one, even with wrong numbers, restores normalcy. What the law demands is not truth, but documentation, and documentation, once stamped, defines truth. The deeper implication lies in the handwriting itself. Comparison under ultraviolet scan reveals that Ames's signature was traced over faint graphite lines, the pen following a pre-drawn contour. It is not a forgery in the criminal sense, but a reconstruction, a mimicry meant to preserve form after authority expired. Whether performed by a clerk or at the request of counsel, the act blurs authorship until authenticity becomes secondary to continuity. The county recorder's office provides a final irony. In its index for 1916, the same estate appears once more, listed under Reconciliation of Property Accounts, certified by Langford, now legitimately in office. The value column lists, as previously verified April 10, 1913. The inconsistency has been institutionalized, a backdated event anchored by signatures that never coexisted, reaffirmed as precedent. Such contradictions should have collapsed the narrative of the estate. Instead, they reinforced it. Each discrepancy made the record less falsifiable, because to correct it would expose too many aligned errors. The system preserved itself by preserving the mistake. If these misalignments had tilted toward loss or confusion, one could attribute them to bureaucracy, but they all lean in the same direction, toward legitimacy, toward balance, toward the convenient fiction that everything remained accounted for. When every inconsistency protects the same interest, can it still be called an error? The document still survives, sealed within the probate volume for 1913. The ink, slightly darker than the surrounding entries, forms a clean rectangular shadow where replacement pages were inserted. The hinge of the binding strains under the added thickness. It is the visible weight of an invisible correction, proof that even within the architecture of law, reality can be adjusted by alignment. And through that tension, the trace between truth and its certified substitute, the next chapter begins to take shape. Not what was altered, but what risked exposure if anyone dared to reconcile the two. By 1920, the danger was no longer confined to ledgers and clerk stamps. The war had ended, fortunes had swollen on contracts and speculation, and New York's tolerance for quiet inheritance had thinned into suspicion. The public language changed first. Newspapers began treating wealth as a civic problem rather than a private achievement. Investigative desks were no longer niche, they were institutional. In that climate, a probate file that should have closed in the late 1890s, yet remained administratively alive through amendments and substitute copies, was not merely odd, it was combustible. The risk was structural. If the record had closed on time, it would have produced a single stable anchor point. A final inventory is an ending, and endings are how accusations are built. In 1920, an aggressive local investigative outlet, one of the city's reform-minded papers that tracked municipal patronage and banking influence, would not need to prove a conspiracy to create a scandal. It would only need to show a sequence of mismatched facts, a late estate, an amended schedule that shrank direct ownership, and a trail of corporate conveyances that never appeared as estate alienations. Those are legible patterns, not theories, and they are precisely the kind that survive a lawyer's denial. The chain could be reconstructed by anyone with patience and access. Start with the probate docket still marked pending. Pull the 1899 inventory and place it against the 1904 supplemental schedule. Note how a category of securities becomes participations held through fiduciary custodians. Then go to the Registry of Deeds and track the East 64th property as it exits the family's name and later exits even the earlier intermediary company. Now bring in the 1913 appraisal confirmation that credits value to assets already dissolved and bears signatures that do not align with appointment dates. That is not a gap. It is a fault line. In 1920, when political figures were already under pressure to appear hostile to privilege, a county official or state investigator would have had incentive to amplify it. not suppress it. The potential legal impact is clear. A closed record would have created a definitive baseline for contest. With a final inventory, a creditor, or a disfavored heir, could argue that assets transferred into intermediary companies were, in substance, estate property moved out of reach. A court could subpoena trust company correspondence, force disclosures, and treat administrative consolidation as self-dealing. The most fragile point would not be the missing art or the renamed securities, but the authorizations, the signatures that permitted sales while the inventory remained unsettled. If those authorizations concentrated in one hand, and if that hand belonged to someone whose authority had lapsed, the fiduciary shield becomes a liability. The accusation would not have to be theft. It could be framed as something more provable: breach of duty, improper valuation, concealment from beneficiaries, false certification. Reputational damage would have spread faster than any judgment. The Ellsworth name, still circulating through society philanthropy, would have been forced into public arithmetic. The trust company's brand, built on discretion and stability, would be questioned at the exact moment post-war America was learning to distrust private governance. Politicians would not need to understand probate mechanics to weaponize it. A single committee hearing, a single headline about estate records rewritten, could trigger withdrawals, donor hesitation, and social exile masquerading as moral outrage. And the most dangerous linkage is the one that doesn't require speculation. Delay creates the conditions for reinterpretation. Supplements do not merely update, they redefine what the past is allowed to have been. In 1920, any auditor looking for a clean narrative would discover the opposite. Amendments that subtract, corporate bridges that dissolve, and confirmations that arrive after the authority they cite has already departed. The storyline practically writes itself: a fortune that refused to become a final number, and therefore refused to become a final responsibility. This is why leaving the inventory inconclusive was not passive. It reduced the risk of a fixed end state that critics could cite as a target. A file that never ends is harder to indict, because every discrepancy can be framed as pending correction, rather than completed deception. The estate remains perpetually in process, and process is the last refuge of those who fear conclusions. By the autumn of 1920, the investigative threat would have narrowed to one act: forcing closure. A public demand for a final inventory would have compelled a single document to reconcile 20 years of movements. That reconciliation was the one thing the system could not survive without exposing its seams. In the Surrogate's court archive, the docket jacket from that era bears a quiet annotation in the clerk's hand: no final accounting filed. The words sit there like an unopened accusation, waiting for someone to insist that the record end. And that insistence leads directly to the next stage: how a long-running absence becomes routine, and routine becomes policy. By 1933, the estate no longer survived because someone protected it. It survived because institutions learned to treat its unfinished state as ordinary. The country was deep in the Great Depression. Banks were consolidating, trusts were being reorganized, and clerks were processing backlogs that made a decade feel like a week. In that environment, pending stopped sounding like an exception and started sounding like a category. A probate file that never reached final accounting could be carried forward without argument, the same way a city carries forward an old ordinance no one remembers passing. Inside the Surrogate's court, the language that once justified delay became standardized phrasing. Old entries that had been written as explanations, pending appraisal, awaiting supplemental schedules, restricted papers, were now copied into new index cards as if they were outcomes. Clerks used them to classify, not to question. The estate's docket number moved from active volumes to a drawer of long-running files marked maintenance, a term that suggests care, but actually means continuity without resolution. It was not a decision to conceal. It was a decision to keep the machine running. That is the crucial shift. Secrecy stopped requiring coordination. It only required procedure. Each year, a minimal action occurred. small enough to look like routine, formal enough to keep the file alive. A stamped notice acknowledging continued administration, a ledger entry noting no final account submitted, a technical reference to fiduciary oversight. These are not dramatic events. They are administrative pulses. And by 1933, the court had learned to accept pulses as proof of legitimacy, because legitimacy in bureaucratic systems is often indistinguishable from persistence. The fiduciary ecosystem adapted to the same logic. Offices that once described their role as settling estates now described it as estate management, a phrase that quietly replaces an endpoint with an ongoing service. The trust company's successor custodians, no longer the original personalities who shaped the early filings, handled the estate like an account type. They maintained it the way one maintains a building: pay fees, renew documents, keep liabilities distant, keep paperwork minimal. Even heirs, now generations removed, learned a practical truth. You do not receive power from a file that never closes. You request allowances from whoever controls it. Over time, that dependency becomes normal, and normal becomes invisible. The action that makes normalization measurable is not a dramatic amendment, but the method of archiving. In 1933, the docket is physically reclassified. The jacket is relabeled. A clerk initials the change and moves the file into a section reserved for inactive estates, where it can remain indefinitely with no hearing scheduled. The move is procedural, not conspiratorial, yet it produces the exact protection the earlier strategy sought. Once a file is treated as inactive, it is rarely revisited unless a new party insists, and new parties rarely insist, because the passage of time erodes both standing and appetite for conflict. Procedure becomes the substitute for agreement. The estate also benefits from the exhaustion of oversight. During crisis years, courts triage. They prioritize contested matters, urgent distributions, living disputes. An old estate with no active litigation and a thin annual footprint becomes the perfect bureaucratic orphan. Not because it is harmless, but because it is quiet. Silence is rewarded in crowded systems. The estate, by remaining technically under administration, avoids the one act that would invite scrutiny: final accounting. Final accounting demands reconciliation, and reconciliation demands questions the file can no longer answer without exposing its seams. The consequence is institutional fatigue turned into policy. The record becomes self-defending. Any effort to close it would require reconstructing history across missing deeds, dissolved companies, and substitute copies, work that no clerk, no auditor, and no modern heir wants to own. So the system chooses the path that systems often choose. It preserves the problem because the cost of resolution is higher than the cost of continuation. That is how exceptional cases become permanent. By the mid-1930s, the estate's paper trail looks clean precisely because it looks incomplete. There are no new revelations, no new disputes, only the steady repetition of administrative phrases that sound responsible while saying nothing. Pending appraisal, maintenance, restricted papers. Words that do not describe truth. They describe permission to avoid truth. In the archive, the evidence of normalization is physical. The docket jacket bears multiple date stamps, each fainter than the last, stacked like shallow footprints. A thin receipt is clipped inside. Filing fees paid, minimal notices issued, no final decree. The file is not hidden. It is simply placed where no one expects an ending. And as the court continues to carry it forward by inertia, the investigation reaches the next and final question: what does a century of pending mean when viewed from the present, and what survives that can still be proved? After 1933, normalization deepened through the smallest administrative habits that never look like policy until they have been repeated long enough to become indistinguishable from law. The estate's file begins to generate what clerks call technical movement, not distribution, not resolution, but a sequence of minor actions that keep a docket breathing. A fee posted all under a generic code, a receipt stapled to the inside cover, A marginal notation that the fiduciary remains available upon request. Each entry is too small to attract attention, yet together they form a durable shield, the appearance of management without the burden of disclosure. In the correspondence that survives from the fiduciary offices, the tone becomes operational rather than legal. Letters no longer reference heirs by name, but by category, beneficiary group, interested parties, family representatives. That language matters because it removes the human trigger for conflict. When people are reduced to roles, disagreements become paperwork, and paperwork can always be deferred. The estate is not resolved, it is handled. And handling is the bureaucratic cousin of forgetting. Court practice shifts in parallel. Notices that once required detailed accounting become minimalist acknowledgments, mailed to last known addresses with no expectation of response. Returned envelopes are not treated as alarms. They are filed as proof of attempt. A system designed to ensure participation begins to treat non-participation as compliance. The estate benefits automatically because time makes all parties harder to locate and easier to dismiss. This is how pending becomes self-sustaining. The longer it persists, the less any institution can prove that anyone still exists to challenge it. The archive record reflects this shift through classification stamps that are not meant to be read by the public. The docket receives internal labels, codes indicating restricted access, limited retrieval, off-site storage. None of these seals a record in the dramatic sense. They simply add friction. Each layer of friction reduces casual inquiry. A researcher must request the file, wait, justify, and return. Friction is the quiet architecture of institutional silence, and it operates without malice. It is efficient. Efficiency, in this context, is indistinguishable from protection. Meanwhile, the world of estate management evolves into an industry with its own incentives. Fiduciary offices derive revenue not from closure but from continuation, advisory fees, custodial commissions, periodic administrative charges that require only that the estate remain open enough to justify their existence. A closed file ends revenue. An open file sustains it. Over decades, the model reshapes behavior. The default response to complexity becomes extension, not settlement. The estate is not exceptional anymore. It is a familiar product. By the late 1930s and into the 1940s, a second generation of administrators inherits the case without inheriting its origin story. That inheritance is decisive. When no one in the office remembers why a file stayed open, the file no longer needs a reason. It has precedent, it has routine, it has a folder with receipts. At that stage, even a well-intentioned clerk faces a problem. Any attempt to close the record requires reconstructing decisions made by people who are dead, involving entities that no longer exist, referencing attachments that were never filed. Closure becomes not an act of justice but an act of risk. Risk to the court, to the fiduciary, to the institution's reputation for order. The estate's secrecy then becomes passive and collective. No single actor has to hide anything. Everyone simply follows the path that avoids creating a definitive statement. Definitive statements can be disproved. Indefinite status cannot. The file's stability rests on its refusal to declare what is true. This produces a final institutional consequence. The record becomes administratively clean by being informationally thin. There are fewer pages to contradict each other, fewer line items to audit, fewer signatures to question. What remains is a skeletal continuity, a docket number, periodic fees, and standardized phrases that have outlived the conditions they once described. The estate is not maintained as truth. It is maintained as a status. In the physical file, the clearest sign is the absence of the one document. Every probate process is supposed to culminate in a final accounting signed, reviewed, and closed by order. Instead, there is a repeating pattern of placeholders, forms that gesture toward resolution without ever approaching it. The papers do not conceal facts. They conserve a posture, and that posture has a cost. A system that normalizes pending trains itself to accept unresolved wealth as administratively acceptable. It teaches clerks to treat silence as stability and teaches fiduciaries to treat time as an asset class. The estate's mystery no longer depends on secrecy. It depends on the fact that procedure has replaced curiosity. The record does not end because endings require responsibility. It persists because persistence requires only stamps. At the back of the folder, behind the last receipt, a blank index card sits unused, reserved for final decree. It was never filled in. The card remains. Clean, not because nothing happened, but because the system learned to survive without saying what happened. And from that learned silence, the investigation can finally turn to the only remaining leverage: what the present can still retrieve, and what the surviving record refuses to explain. The digital record opens in 2026, inside the New York County Surrogate's Court Online Archive, where the docket number still exists, unchanged since 1898. The screen lists it as active in maintenance. No final accounting, no disposition order, just a fragment of language carried forward into a century that no longer understands what it means. The case persists not as a dispute, but as metadata, a ghost of administrative endurance. When searched, the interface produces a single PDF labeled Estate File, Legacy Conversion, last updated May 2024. The file contains scanned pages of the original ledger, faded typewritten supplements from 1904, and a notation from 1933 identifying the case as transferred to microfilm. The digitized image ends there. No closure, only translation into a new format. The building that once anchored the case, 41 East 64th Street, still stands. Its limestone facade is immaculate, restored under the oversight of a preservation society that advertises itself as dedicated to conserving Gilded Age architecture for public appreciation. The brochure displayed at the front desk lists the mansion as formerly associated with the Ellsworth family, noted patrons of the arts, but makes no mention of the decades-long probate that financed its transformation. The narrative offered to visitors is curated for comfort, elegant philanthropy, tasteful endurance, a story of legacy rather than possession. Across digital and physical space, two narratives now coexist without touching. The first is the visible one: museum, preservation, continuity. The second lies inside the county's data system, where the estate remains legally unresolved, suspended in administrative syntax. When compared, the dissonance is precise. The Society's plaque dates the completion of the estate's transfer to 1904, though the 1904 supplement was never final. The plaque's author likely borrowed the date from a real document, unaware that the document itself was an amendment built on erasure. Thus, public memory confirms what the record never proved. The archivists who digitized the file did not attempt to reconcile the inconsistency. Their notes cite incomplete historical data, file retained for reference. That phrase is the modern descendant of the old pending appraisal. It extends the same institutional courtesy, the privilege of remaining unresolved under the guise of preservation. No one is concealing anything. The system simply reproduces its oldest habit, keeping unfinished things accessible but unchallenged. In 2026, a request for full inspection of the probate file requires formal authorization through the county's digital portal. The process is automated. Select Request Document Access, specify a purpose, agree to terms. Yet when the estate's docket number is entered, the portal responds with an error. Record restricted, legacy archival conversion incomplete. A note advises the researcher to contact the Records and Historical Preservation Division, which confirms by email that the file is classified as historic and non-actionable. Non-actionable, the 21st century's polite synonym for untouchable. The modern institutions, built to preserve transparency, now preserve opacity with equal precision. Digital systems inherit the biases of their analog predecessors. They protect continuity over disclosure. The estate's incompleteness is no longer scandalous. It is procedural legacy, A closed file would require explanation. An open one only requires storage. The same mechanism that once safeguarded wealth through delay now safeguards history through access control. Meanwhile, the family's public identity has long been rehabilitated. The Ellsworth Foundation for Historic Arts, incorporated in 1982, funds exhibitions, restorations, and educational programs about New York's cultural inheritance. Its headquarters occupy the former residence itself. On the Foundation's website, the family story is summarized in 3 sentences. Descended from 19th century patrons of architecture and design, the Ellsworth family's commitment to civic preservation reflects an enduring vision of continuity and trust. The word trust carries no irony, though its earliest meaning in this story was literal. What survives materially, the house, the plaque, the archive, constitutes an aesthetic of legitimacy. The longer the record stays unfinished, the more complete the myth becomes. The public sees heritage, the court sees maintenance. Between those two versions lies the unresolvable distance between narrative and accountability. The estate's history teaches a structural lesson. The elite never needed to destroy records to protect themselves. They only needed to ensure the record could never conclude. In the final scan of the digital docket, the last visible page is a 1933 memorandum, stamped, transferred to microfilm, no further action required. The preservation tag added in 2024 repeats the phrase, unchanged. A century apart, the same words perform the same function, postpone the end indefinitely. The modern reader sees a stable archive, but stability is only the last disguise of delay. A file that outlived everyone responsible for it now functions as proof that incompletion itself can become heritage. At the edge of the scanned page, faint pencil lines from the original clerk remain visible, a nearly erased note. Final decree to be prepared. The phrase was never crossed out, only faded, and that is where the record still ends. What stands out in 2026 is not that the case is difficult to solve, but that it has been engineered to be difficult to finish. Modern systems can search names, dates, and addresses in seconds, yet they still depend on a principle older than the courthouse itself. An official narrative is whatever the file can support without forcing an ending. The estate's docket survives as a reference object, not a live obligation, and that distinction shapes everything that can be learned today. When contemporary researchers trace the estate through secondary records, tax fragments, corporate registries, and preservation documentation, the pattern repeats. Plenty of testimony about presence, almost no proof of responsibility. A foundation newsletter can describe the family's stewardship in warm terms, and a tour guide can attribute renovations to benefactors, but neither has to reconcile how stewardship was funded or how ownership legally moved. The records that would answer those questions are not missing in the dramatic sense. They are compartmentalized, distributed across jurisdictions, absorbed into defunct entities, and sealed behind procedural qualifiers. That treat inquiry as a special case rather than a default right. This is where the present becomes the most revealing. In a modern property database, ownership is usually transparent. A name, a company, a chain of deeds. Here, the chain exists but refuses to form a single line. It breaks into corporate fragments, then recombines under successor entities that look clean because they began after the controversial period. The effect is that the past is not erased, it is modularized. Each module can be explained on its own. None can explain the whole. The most practical obstacle is not access, but interpretability. Even when scans are available, crucial linking metadata is absent. Annex references without annexes, page numbers without attachments, certifications without underlying schedules. A digital archive can preserve an incomplete file indefinitely, and by doing so, it turns incompleteness into a permanent state. The record becomes a museum piece, valuable, browsable, but not actionable. It allows public fascination while withholding legal consequence. In 2026, this produces a new kind of legitimacy. The Preservation Society's work is real. The building's conservation is tangible. The exhibitions have catalog numbers and sponsors. The public is invited to feel gratitude toward heritage. Yet heritage in this case is partly the byproduct of a process that never accepted the discipline of final accounting. A clean public narrative emerges not because the history is clean, but because the only surviving, easily consumable story is the one that avoids the question of closure. The estate's endurance also reveals a deeper institutional preference. Systems protect themselves by avoiding the kind of finality that could imply earlier failure. If a modern court were to declare the file conclusively closed with missing information, it would be acknowledging that decades of maintenance substituted for resolution. If it reopened the case, it would be admitting the record still matters legally, inviting demands it cannot satisfy without exposing its internal contradictions. So the safest position is the one the record has held for generations. Neither closed nor confronted, simply present, like an artifact. That is why the legacy remains intact. Not because the facts were successfully hidden, but because the structure ensures no single moment forces the facts to assemble into an accusation. The public receives a romanticized name and a curated narrative. The archive retains fragments that look official. The gap between them is where accountability should live, and where it cannot, because accountability requires a final statement. One document that says, "This is what existed, this is who controlled it, and this is how it ended." The estate never produced that document, and every system that inherited the file has treated that absence as tolerable. The result is a model that outlasts the family and even the institutions that first enabled it. You do not need to erase everything. You only need to prevent the ending that would make everything count as evidence. In that sense, the present is not a conclusion. It is the continuation of a technique. Keep the record accessible enough to appear transparent, incomplete enough to remain harmless, and unresolved enough to avoid responsibility. In a quiet way, that is the most modern outcome imaginable. The estate has become a public object with private logic. The mansion can be photographed. The foundation can be celebrated. The docket can be searched. But the moment you try to force the story into a single accountable line, the file behaves exactly as it was designed to behave. It stops. In the arc from 1898 to 2026, the record never truly breaks. It only changes hands, changes language, changes format, until the original purpose is no longer recognizable, yet the machinery remains. 1899 gives us an inventory that arrives already incomplete, not as a flaw in ink, but as a choice in structure. 1904 follows with supplements that do not clarify what existed, but refine what may be admitted. 1907 rewards the ones who can control time while the world panics and institutions tighten their grip. 1913 leaves behind a confirmation that cannot align with its own chronology, a signature and a date that fit too neatly into the shape of convenience. 1933 turns the extraordinary into routine, until pending reads like a policy rather than a problem. And then 2026, a digital docket, an easy, elegant plaque, a preserved facade, offers the final irony. The legacy looks complete precisely because the record never was. This is the institutional lesson that the mansion's corridors cannot display on a tour. Inventories are not only meant to list possessions. They are meant to end an official version of what existed, what belonged to whom, what was valued, what was transferred, what was owed. They are the closing doors of probate administration, the moment a fortune is forced to become a statement rather than an atmosphere, and when the door never closes, the statement never arrives. The truth remains movable, not by magic, not by myth, but by calendar. Open the chain once in a single line, and the design becomes visible. A death and a docket opened, an inventory filed incomplete, a decision to delay, supplements that subtract, a beneficiary empowered by administration, assets that stop existing on paper, an inconsistency that stabilizes the narrative instead of breaking it, a scandal avoided by never allowing a final page, a bureaucracy that learns to call inertia maintenance, and a present-day legacy that inherits the aesthetic of certainty while the record keeps its fractures. What evaporates does not vanish into darkness. It simply escapes the moment when evidence is fixed. That is why an unfinished inventory is not merely an oversight. It is a tool. It keeps responsibility suspended in administrative air, where it can be referenced, admired, and archived without ever being tested. The court clerk, the trustee system, the probate apparatus, none of it needs to conspire once procedure can do the work. A file that never ends cannot be conclusively contradicted. A fortune that never becomes final cannot be fully accused. And if you listen closely to the way these halls preserve themselves, through plaques, catalogs, curated language, you begin to hear what is not said. The silence is not empty. It is structured. It is renewed. It is filed. If this story resonated with you, let us know. It tells the algorithm these forgotten halls are worth exploring again, and it keeps this investigation alive where so many records were trained to fall asleep. Leave your thoughts below. Every perspective helps illuminate what history tried to bury, and if you choose to subscribe, do it quietly, almost ceremonially, so that you're here when the next sealed door finally opens. Because this file is not alone. There are other dockets that never reached their last page, other inventories that remained pending until the object itself changed shape, other legacies that survived by refusing to become evidence. And if you're willing to step deeper into the shadows, the next chamber awaits. Some secrets survive only because those who feared them left no one to tell the truth.